Hello, I'm Edgardo Villanueva, President of EMSI Consulting. Welcome to this edition of our feature called What the Experts Say. In this particular video interview, I'm glad to have the opportunity to have had a chance to speak with Lawrence Postol, a chief partner at the DC office of the law firm of Safer Shaw. Mr. Postol is an expert in labor and employment relation matters. And in this particular case, he agreed to speak with us about some of the new developments under the American with Disabilities Act, the ADA. Mr. Postol was kind enough to give us his time and expertise and answer some key questions which are included in the interview. If you have any questions afterwards or comments or would like to speak with either he or I, the information for contacting us will appear on the screen. Meanwhile, I hope you enjoy the interview. So let's just dive into it, Mr. Postol, and I want to ask if you could please begin by giving us some background on the history of the ADA and how it came to become the law of the land.
Okay. Basically, in 1991, when the first President Bush was president, he proposed that Congress enacted the American with Disabilities Act with really no major opposition, and that's not really surprising. Basically, you're taking a group of people who have disabilities, some as severe as being blind, deaf, others having great physical disabilities, and we're trying to level the playing field so we can get them back to work. And many of them are on disability benefits, Social Security disability, long-term disability, so it's a win-win situation. A lot of these people will prefer to be working, and it helps the productivity of the country to get them to work. So the bill itself came in without much opposition, and it seemed like a simple enough proposition. When it was enacted, actually, in 1991, I actually wrote a law review article on it, and I can still remember giving a lot of speeches saying, boy, this is really going to change things because the definition of disability was so expansive, and the requirements of reasonable accommodations would be something most employers would not be used to and might not like. As it turns out, I was wrong, that in fact the courts were very conservative in interpreting the ADA, and so most employers didn't really have to do much because the plaintiffs tended to lose their cases. And the reason for that was twofold. Well, there's actually two Supreme Court case decisions that greatly limited the ADA. First was a Supreme Court case that said, in considering whether someone has a substantial limitation on a major life function, which is the definition of a disability covered by the ADA, they said, we're only going to consider the employee as they are after corrective measures. So, for example, I might have terrible hearing, but if you give me a hearing aid, I can hear fine. I might be bipolar, depressed, but you give me medicine and I'm fine. I sort of will date myself saying when I grew up as a kid, there was this movie, The $6 Million Man, which is basically somewhat come true now, that we can put people back together, give them parts, and they're not really better than they were, which they were in the movie, but we can reduce a lot of the effects of disabilities. So what's happening is a lot of courts were saying, you know what, you're not really disabled. That yes, you've got these terrible things, but after corrective measures, you're not that much worse off, so you're not covered by the ADA. The second thing that happened was a lot of employees would go overboard to show that they were disabled. They were sort of caught in this catch-22, so they would get doctors to give really severe restrictions, really point out terrible limitations, at which point the employer could then turn around and say, well, there's no reasonable accommodation that would allow you to do the essential functions of the job because you're so disabled. So this went on for basically till 2008, and finally Congress said, we've had enough. You know, we didn't mean this to be the way it turned out. We thought a lot of people were going to be covered, and we really didn't think the fight should be over whether someone's disabled. It should be over what reasonable accommodations you should provide people so they can work. So Congress amended the ADA in 2008, and they basically, not basically, they did reverse several of the Supreme Court decisions. There was another Supreme Court decision that said someone with carpal tunnel syndrome that worked in a factory wasn't disabled, even though the carpal tunnel syndrome prevented them from working in the factory, because the Supreme Court said, well, there's lots of other jobs they could do. Mm-hmm. So the Supreme Court reversed, Congress reversed that decision explicitly in the 2008 amendment. They reversed the decision about using corrective measures after that you use those and then look at the person afterwards. And in the 2008 amendments, Congress said, look, you need to look at the disability just alone, forget about the corrective measures, that this Supreme Court case about carpal tunnel syndrome was totally wrong, that we don't want that followed. And then they enhanced the definition of what are major life functions to determine what if somebody has a disability. Bottom line is the 2008 amendments now basically say if you have anything chronically wrong with you, diabetes, hypertension, arthritis, you're covered by the ADA. And Congress explicitly said that the fight should be over what reasonable accommodations are given. The problem I see is employers really haven't caught up with this yet. I give lots of speeches. I still write articles on the ADA, and I'll give speeches not to factory managers, but to human resource professionals who you would assume would understand what the ADA requires, but basically because they haven't really had to comply with it for the last 20 years or so, they just haven't followed it. So one question I always ask, I'll have 100 people in the audience, and I'll say, okay, what's a reasonable accommodation of job restructuring? I'm lucky if one HR person raises their hand that they know what job restructuring is, and yet that reasonable accommodation has been in the Americans with Disabilities Act since 1991. So it's clear the employers just aren't caught up yet.
That's too often the case, unfortunately. So your article pointed out that there's like a whole new set of human conditions, and you've alluded to some already, but briefly, beyond physical disabilities, which is what one would imagine initially, that now the EEOC considers as valid disabilities. What are some of these new conditions or these new situations that would have heretofore or before not been considered,
Sure. Well, sort of two big categories that come to mind are, one, chronic conditions that there's something wrong with the body, but it really doesn't affect you in your job. So things, again, like diabetes. I can have diabetes, but if I take insulin, I'm okay. Hypertension. Lots of people have high blood pressure, and it really doesn't manifest it as having a problem. Right. And yet Congress has said we want them covered by the ADA because even though it's not a big problem on the job, there still may be accommodations that people need. So, for example, I might need a break to take my insulin. I might need some change in my job so it doesn't cause my blood pressure to go up. So you'll have any chronic condition can be covered even though it doesn't really have an effect on the job and doesn't seem to be that big a problem on the surface. The other big area where they greatly expanded it was mental disabilities. Now, the ADA always covered mental disabilities, but in determining what life functions are, and therefore what, if substantially limited, will be covered by the ADA, the Congress and the EOC and the regulations included a lot of mental processes, so cognitive ability, mental thinking, so that anytime someone has a mental problem, if you will, that's going to be covered by the ADA as well. So if someone says, I have attention deficit disorder, I can't focus as well on the job, you can't just blow that off. That's a covered disability, and you need to talk about what reasonable accommodations are. And that's particularly problematic for employers because while most employers, even though they're reluctant, at least can get some handle on a physical problem, you can see it, you can feel it, most of the time a doctor can test for it. Obviously, none of those things are true about mental disabilities.
In your practice, what mistakes do you commonly see that companies commit that could lead to problems when in regards to this subject of the ADA?
Sure. Well, you get sort of different levels, if you will. So you have some employers who, I don't want to take anybody to work who has any work restrictions. I only want people who are at full duty. Well, there's no way that's valid under the ADA And so those employers I put in the category, they have absolutely no idea what they're doing,
Yeah.
and they're going to have a big problem.
Right.
The next sort of category is, you know, I don't want to hear about it. These accommodations are too hard. There's something in the ADA about undue hardship. This is clearly an undue hardship, so we don't want to do it. And the problem is that managers are judged by their productivity. So if I'm a manager, I want to maximize productivity, so I want the healthiest, best working workers I can get. Well, that's nice, but that's not what the ADA requires.
Right.
And the other thing is, for some small employers, the cost of the reasonable accommodations, even though it can't meet the definition of a legal hardship, is still can be burdensome from it.
Right.
And sometimes, frankly, it's just employers being foolish. So, for example, we had one case where there's a secretary, she had carpal tunnel syndrome, and the employer said, well, you know, we need to get a evaluation to see if she realized carpal tunnel syndrome. We need a functional capacity exam to see what she really can do and can't do.
Mm-hmm.
And basically, I just said to the employer, I said, well, what does she want? Well, she wants some crazy keyboard that was rounded and that had strange dimensions. Supposedly it was better for people with carpal tunnel syndrome. And so my next question was, well, how much is a keyboard? And I said, $99. I said, get her the keyboard. So, you know, and they said, well, but we don't know her medical condition. I said, look, it doesn't matter. It'll cost you $99. She thinks it's going to help, so it will help. So a lot of times there are simple solutions, and employers just don't always have the patience to find the simple solution.
Right, as the old expression goes, of penny wise and pound foolish. And that leads me to the next question I want to ask you is, what types of consequences and monetary penalties could employers face if they are found guilty of violating the ADA?
Sure. Well, you could be liable for back pay. So oftentimes in these cases, the employee is fired. The case sits at the ELC for a year or two. Then it gets litigated for a year or two. So you could be paying an employee for the last 3 or 4 years their wages, benefits, for which you got no work out of them. So that's back wages. You have to reemploy them if you wrongfully terminated them, and provide the accommodation if the court finds there's accommodation you should have provided. They can get up to $300,000 punitive and compensatory damages.
Mm-hmm.
Compensatory damages are, I'm pain and suffering, it was embarrassing, give me money. Punitive damages are, the jury says, we think what you did is really terrible, so we're going to give even more money. So there is a $300,000 cap under the federal law. Now, a lot of state ADA statutes don't have that cap, so it might be even more under state law. And then lastly, but sometimes the worst, is the attorney fees. So you not only have to pay your attorney, but if you lose, you have to pay the other side's attorney. And as these cases drag on, it can be hundreds of thousands of dollars in attorney fees. Sometimes it can even exceed $1 million. So it can be very expensive to do it wrong.
That goes to, without saying, therefore, that to get good advice up front from an attorney or, you know, some other professionals in the area is well worth the investment, shall we say, in order to avoid those types of penalties. To close it up here, Mr. Postol, what do you think the future will hold? What are there any other areas that you feel that the ADA is going to continue to expand into and that companies will have to adapt to in the future?
Sure. Well, I think one of the areas that we're already starting to see problems, and I think it's only going to get worse, is the accommodation of telecommuting or working at home. Mm-hmm. So for a number of years, courts just sort of blew it off. They said, look, everybody knows the essential duty of a job is you have to be there, interact with your coworkers, customers, supervisors, face to face. Sort of old school, which I'm probably still in that school, I must say. The trouble is, most employers have now voluntarily gone to allowing workers to telecommute 1 day a week, 2 days a week, 5 days a week. Right. Frankly, I have my own doubts about it. Partly, maybe it's my own prejudice. I'm not very productive at home. I just think if someone's not watching, they may not be working as hard. But the trouble is, if you allow non-disabled workers to work at home, you are conceding that it's not an essential function that they work at home. And so, you know, it's one thing to have your best, most trusted worker telecommute 1 day a week because you know they're a maniac, they're going to work hard no matter where they are. It's another thing to have one of your worst performers tell you, walk in and say, I want to telecommute and work at home, and come in with a doctor's note that says that. And yet, if you allow the other workers to do it, and it's a reasonable accommodation, now you're going to get stuck with it. So I think the accommodations we're going to see, including working at home, are going to get more and more expansive and be trickier for employers to work through. Now, I'm not saying you can't. For example, we had one case where the worker came in with a note. We ended up getting an IME, independent medical examination, by a psychiatrist of our choice, and the doctor said, no, she doesn't really have to work at home, that there are other accommodations you can make at work to make it work. But it's problematic. I mean, one of the most common work at home is, I hate my supervisor, my supervisor's mean, I now have a stress claim, so give me a new supervisor. Well, you know, this is now almost by definition one of your problem employees, and yet they're asking for a reasonable accommodation. They've got a nice psychiatrist note that says they're stressed out, they have anxiety. Psychiatrists have more terms for more conditions. I think if you had every American in front of a psychiatrist, they could give you a diagnosis for them. So I think those kind of areas, I think, are going to be more and more problematic for employers.
Absolutely, and we'll look forward perhaps to other opportunities to continue to get updates from you with regards to this important and emerging issue. So I want to thank you again, Mr. Postol, for your time and for your valuable advice here. And to those who are viewing this this program, I want to, of course, indicate that if you have any questions or any particular situations, you can certainly contact us here at EMSI Consulting, and we will also make available the contact information to reach out to Mr. Postol directly. So once again, sir, thank you very much for your time and for your valuable advice.
My pleasure.